He's a patent attorney, law professor, and leading commentator on patent law and innovation policy. Joseph Root. Joseph is the founder of Qualipat and has served as both IP and general counsel, in-house and out, for corporations and law firms. He is also the author of Rules of Patent Drafting, Guidelines from Federal Circuit Case Law. Thank you again to everyone for attending today's presentation. And with that, I will turn it over to Eugene.
Okay, thanks a lot, Gail. And thank you, everyone, for being here and joining us today. And thanks, Joe, for joining us for this conversation, which I think will be a pretty interesting conversation. We have a lot of ground to cover today, and it's always nice when you have somebody here who has actually written the book on the topic that you're talking about. So, and you're probably seeing that slide right now. And the next draft of Joe's book is actually, this is quite timely. We didn't plan it necessarily to coincide this nicely with when the next release date is, but the next edition of the rules for patent drafting will be available May 10th. So if you're interested in that, please definitely look out for it. And those of you who read IP Watchdog, you probably know that Joe has been generous enough to write for us several times over the last few years, and that's a link to the articles that Joe has written about patent application drafting. So you can check that out. I think you'll find that useful. Here's an outline of what we hope to accomplish today. Now, this is really going to be quite a lot to do. I think we're going to be able to do most of this, but because we want to take as many questions from you as we can. So if you have questions, please feel free to shoot them to us during the conversation. The premise is, of course, that patent application drafting is a daunting task that made even more daunting today based on the fact that the PTAB is an omnipresent reality, and anything that is commercially valuable seems like it will wind up being challenged there at some point in time. And patent owners don't tend to fare very well there. So you have to really start doing this stuff right from the very beginning. Now, not everything that we're going to talk about today is relevant for an IPR because, of course, for IPR you can only raise 102 and 103 concerns, which we will talk about a little bit. But we're going to also talk about 112 matters and 101 matters as well, so kind of talk about a variety of drafting issues with a focus on what's been going on recently. So we're going to start with Nautilus, then we're going to talk about the specification, and then we're going to wrap up with talking about Alice with 101 rejections, and then 103, and I kind of see Alice and 103 as that's sort of the same topic there. Because the point I want to get to is, as we see when we talk about it most directly, is the touchstone anymore is about what is the improvement, and we just don't write patent applications anymore to identify the improvement because of KSR concerns primarily. So we have to weigh those, the good and the bad there, and we'll talk about that. Joe, before we get going with our first substantive slide, I want to give you an opportunity to kind of lay the foundation if you want. What do you want people to keep in mind as we embark upon this conversation about patent drafting today?
Hi, folks. My name is Joe Root, and welcome to the webinar, and thanks for attending. Basically, what I wanted to focus on, and it really doesn't matter which part of the application we're talking about, because I think we're in what I call a witty-wig world. What you disclose is what you get. And what seems to be happening with increasing frequency over the last couple of decades is that the Federal Circuit is trying to determine exactly what the inventor's intent was. So you read case after case, and what the judges seem to be looking for is what did the inventor intend, and which is a strong departure from exactly what do the words say to a person of ordinary skill in the art. And I think those concerns go across definiteness, the basic specification drafting, everything to do with Alice and all the 101 cases, and particularly extending into obviousness analysis. So the specification and clearly disclosing what the broad scope of your invention is I think the most important topic today, and it's one that I'll be coming back to.
Okay, great. And that's a good place to start our first slide here, the Nautilus surfaces, with a nice little picture from Jules Verne with Captain Nemo looking out a window of the Nautilus. We're going to talk about the Nautilus case and decision here. Before we do that, what we're going to try and do, if we can pull this off, is we're going to try and do a poll of the audience just to kind of get a sense here. And the question, and there's the poll question that's popped up, is, has the Supreme Court decision in Nautilus changed the way you draft patent applications? And, you know, it's a simple and yes, no are the answers, and I realize that the answer probably may be somewhere in between, but please try and, you know, give your best yes or no answer just to kind of give us a guide, and we can talk about that and see. And this is an interesting question, Joe, right? Because, you know, I think when we go through these slides and we get to what the Federal Circuit is doing, it seems to some extent like maybe things haven't changed as much as we thought they were going to. Is that fair to say, you think?
Oh, absolutely. I mean, time after time, the Supreme Court writes a decision where they just wail the living daylights out of the Federal Circuit, and yet when you pick the situation up about 5 years later, not much has changed. You know, maybe the labels tend to change a lot, but the substance of the analysis winds up being pretty much the same. And I think we're going to see a lot of this here, because I think if you go back and apply the reasonable certainty test to previous decisions that turned on insolubly ambiguous, I don't think you're going to find very many instances where the result would have been markedly different.
Yeah, I think that's probably true. And just for those of you who maybe aren't steeped in knowledge of the Nautilus case, you might recall, or maybe I'll tell you in the first instance, prior to Nautilus, the test from the Federal Circuit was in determining whether or not something met the definiteness requirement was, is it insolubly ambiguous? And the Supreme Court just hated that, because they actually went through in the decision and they said, you know, that they don't really want to second guess the language the Federal Circuit uses for the tests, except for when it is so hopelessly, I don't think they use the word misleading, but so hopelessly capable of leading to different results based on who the decision maker is. So they had real problems understanding what was meant by insolubly ambiguous. So they really came up with the reasonable certainty test. And it seems like, in a lot of ways, the Federal Circuit is just applying the same kind of approach to that. And these last two slides, for those of you who are interested in reading through Joe's most recent writings for IP Watchdog, the title of his article was The Nautilus Surfaces, so that's what the title for these slides come from. And this is taken from that article that you wrote, which I think was an excerpt from your book, right, Joe?
That's correct, yes. That's the chapter on definiteness, or part of the chapter.
Tell us a little bit about the Young case and what was going on here, because that's really where I think you come to the conclusion that not a lot really seems to have changed.
Yeah, so look at what was going on there. Basically, this was about a method for surgically removing the claw of a cat, and the patent language talked about forming an incision near the edge of a portion of the claw. Now, what does that mean? Near the edge is going to differ depending on exactly, you know, I'm not that familiar with cat's paws. I've seen a lot of cats, but you know, the size of the cat, the breed of the cat, and so on. But what the court went back to was, what does a person of ordinary skill in the art take from that term? And as it turns out, when you're talking about near the edge, the evidence showed that a veterinarian of ordinary skill in the art getting ready to perform this surgery would have no trouble figuring out what was meant by near. And you know, and so what I get from that is the court used to look at what the person of ordinary skill in the art was going to get from the claim language, and we're at pretty much the same place today, though we're going to put some different labels on it.
Yeah, no, I think that's right. I mean, it's really the same exact place. It's just we have to call it something different to please the Supreme Court. Now, it looks like the poll has ended here, so hopefully we'll get the results based on the question here coming up in a moment. Gail, when you have those, if you can pop those up, that'd be great. But when I was reading your article, Joe, this case, the Bunch of Balloons case, which is from January of this year, came to my mind. And this is, and one of the reasons I like this case, it so sticks in my mind because we've bought this particular product before, summer barbecues and so forth. The kids all like to have water balloon fights or whatever, and it's just a great invention. It's you can fill up like 50 or 100 balloons simultaneously, and then when they get filled, they just fall right off of the little gadget that fills them, and they're tied tight with, I think it's some kind of a small rubber band. And, you take the tedious task of filling up water balloons, and in very little time, you can have like an arsenal of water balloons. So it makes it much more enjoyable and fun and easy, and, you can see it's a cool invention. It's not something that, it's not high-tech maybe, but it's really cool, interesting, and it's making money. And so, of course, that means there's patent litigation that's being involved. And the question here dealt with the term substantially filled. And what is substantially filled? And Telebrands said, well, we don't really know what substantially filled means. The specification doesn't define what substantially filled means, and the Federal Circuit just, Judge Moore, really, she went off on this, saying that she wasn't going to say that the word substantially was ambiguous or indefinite because it's a word that gets used all the time in patents everywhere, and it says when it gets filled, if it's substantially filled, the balloons will fall off. So she writes at the bottom here of this slide, to put a fine point on it, if the balloons detach, then they're substantially filled. And then the best text for what we're talking about here to wrap up that point from the Young case you were just making is, and I didn't really notice where they were citing Nautilus, but this is clearly a Nautilus concern, is we find it difficult to believe that a person with an associate's degree in science or engineering who had read the specification would be unable to determine with reasonable certainty when a water balloon is, quote, substantially filled. And, that's just a great quote. I love that because, and the reason it's relevant is because Telebrands, who was challenging it, had acknowledged or admitted that the person of skill in the art was somebody with an associate's degree in science or engineering. And so, again, we see that although the language of Nautilus may be changing, the focus is on who is the person of reasonable skill and what would they understand by the language that's being used. Thoughts on this case, Joe?
Yeah, and now that everybody has put in their answers, I don't want to influence anybody, of course, in the academic integrity of this poll, but I would say that that drafting should actually not have changed very much, or if at all, under the Nautilus rule, because what, in my view, what a drafter should have been doing all along is making sure that from the specification there is no question in the mind of a person of ordinary skill in the art what the parameters of the claim language are. And you know, here, you know, I can almost see Judge Moore listening to the Telebrand's argument and just kind of leaning forward and saying, seriously, counselor, would you give me a break? You're trying to say we don't know what substantially filled means?
Yeah. No, that's exactly right. I mean, so I think, you know, sort of the take-home here is, yes, we as drafters need to be mindful, I think, of Nautilus. But I also think if you're challenging patents, you got to also be careful that you're not over-reading what Nautilus really did or changes, because you can sound foolish, I think.
I think that's right.
So, Gail, do you have the results from the poll, just to wrap this up?
I do have the results from the poll. It's difficult for me to get them to show up at the moment, but essentially 22 out of 170 people answered yes, 64 answered no, and 84 gave no answer.
Okay, so roughly,
and I'll try to put that graph
like
up.
Around, what, like 70% said no, something like that, 65, 70% said
64,
no?
Yeah.
Yeah. So, and that's probably what I would suspect, you know, and we probably, if we had given you all more fine-tuned answers, because I think the answer is well, you're probably mindful of Nautilus when you're writing, and hopefully you're doing it maybe a little bit tighter than you might have done in the past, but I don't think that this was the decision where it just wholesale has to change the way you were drafting. Right, Joe?
Yeah, I think that this is one where it seems to me that the people who argued that the sky was falling on this one were overstating things. We got plenty enough things to look around in the 101 realm and say the sky's falling. I don't think that's happening here.
Right. Okay. All right. Now, one of the things, you know, and this webinar is obviously sponsored by Nexus and Reed Technology, Reed Tech, who have been longtime sponsors for me at IP Watchdog. But one of the tools that they offer is Patent Optimizer, and it gives you the ability that if you are interested in really trying to make sure that you're using these terms properly, which we will see in the next segment of substantive stuff that we talk about, is maybe going to be even more important than it is with respect to the Nautilus issues that we just talked about. You can go through your applications that you've drafted and really make sure that they're as tight as they possibly can be. And I mean, it's almost hard to believe that Patent Optimizer can do all the things that they can do, and I'm not going to try and tell you everything that they can do. If you're interested, you should really get a test drive. But you can use it to see what prior usage has been in other patents with respect to that term, if any of the terms you're using have been interpreted by courts, whether there's any alternative meanings that would be appropriate. And you can also identify claim anomalies and whether you have support for the terms that you're using in the specification, whether or not they're definite or not, whether those terms actually in the claim show up in the specification and so on and so forth. Which I think is just a great tool. And the one thing I want to stop here, Joe, and I wanted to talk to you about and we talked about this in our prep call. I've started hearing, and now it is in the art units that deal with what would be Alice art units and the really low allowance rate Alice art units. So maybe there's some game playing going on in there. But I've started hearing patent attorneys saying that they are getting rejections for 112, lack of support for what's in claims. And then when they point out to the examiner that that is actually in the specification and point to where it is in the specification, the examiner continues to hold on to the 112 lack of specification rejection. And I've had people tell me, they say, oh, well, yeah, you put it in the claim, but you only mentioned it one time in the spec. So I'm still going to say there's no support. Well, clearly that's idiotic. I mean, because they're admitting it's in the spec and they're admitting that it's the support. But I think in some areas we need to stop thinking about minimum support. We need to start thinking about maximum support. Would you agree with that?
Yes, absolutely. And the best way to get that is to expressly define terms. I mean, if anybody that the people that I have been involved in training, they have heard me beat them over the head time after time after time that you need to expressly define terms, and you can do that in a very formal fashion. You can do that in a fairly informal fashion, as long as it's evident that you're saying that. For example, if the tennis folks had said that, as used herein, quote, substantially filled, unquote, means that the balloon falls off of the retainer. That's, that's you have set something out in ways that I mean, no reasonable person can look at that language and argue that the meaning of the term is not clearly set out.
And let me stop you there, because when I've read the stuff that you've written, one of the things that I've always appreciated, Joe, is you talk about these rules, and then you also talk about the case and say, okay, well, it turned out okay this time, but at what cost, at what expense? And that's really what we're talking about here, right? I mean, a lot of these rules that we say, don't do this, don't do that, it's not because the Federal Circuit ultimately got it wrong, quote unquote, but it's that they had to decide it in the first place, and that there was doubt as to which way they would go with it. I mean, that costs, uncertainty costs time and money, right? I mean, that's what.
Yeah, I mean, you look at what a trip to the Federal Circuit is going to cost your client, and you're talking well into six figures there, and if very often in 112 definite cases, you're talking about the difference basically of an additional sentence in the spec that sets something out clearly, and that is a really expensive sentence, and so it's really worth spending the time now to make sure that everything is clear. Because winning in the end there is great, but it's going to be very expensive.
Now, we have a question here, and I think it's a really good one that we should talk about, is if the answer is expressly defining the terms, then aren't we really chasing turtles to some extent, since the words of the express definition themselves may then need to be expressly defined? So I guess really the question is, at what point does it end? At what point is defining over? And do you run risks if you do define, but you don't define enough?
Well, yeah, it is. It is. It's turtles all the way down, as the guy once said. And the problem is you've got to be. I mean, it's like, when do you stop writing the specification?
Well, that's usually when the client is run out of money.
I mean, and that, unfortunately, in the real world,
the problem, right? That's the problem we're facing. Is the budget.
If somebody, if you have done, I mean, increasingly we work on flat fees, and if you've got a flat fee for drafting an application, maybe you would like to turn out a 100-page spec with 4 levels of definition for every single term, but very soon you're going to be on the way to the proverbial poorhouse. You can't do that in the real world. So, basically it boils down to judgment, and there are plenty of terms where one sentence will do the job. There are other occasions when something is going to require more work than that. So, yeah, you're taking a chance. Yes, you are to some extent. You're adding limitations, or you're adding. You've got to think when you add breadth. You got to remember Murphy's first law of combat. and that law is that if the enemy is in range, so are you. You can't get additional breadth without opening yourself up to as a better target for prior art. So you've got to exercise judgment.
Because we got some slides on that point exactly.
Oh, that's true.
Let's move past this and get to them.
I'm having way too good a time.
With Patent Optimizer here that I just wanted to point out is it does an awful lot of really cool stuff with the drawings and checking numbers and adding reference figures as well. So feel free to give that a check. I think Patent Optimizer makes a lot of what we're talking about to make sure that you've got the consistency that you need at a cost that doesn't blow out the budget, really possible. Now, patent profanity. Here's this will get us into an interesting conversation about the specification and the invention, because you don't really, people say don't use the word the invention. And this is a claim from a patent that you wrote about, Joe, and it's for a fuel system. And then it actually winds up being a case at the Federal Circuit, Honeywell versus ITT. And the Federal Circuit writes, Judge Lurie, I think, was the one who wrote this decision, pointing to that at least on 4 separate occasions, the description refers to the fuel filter as the invention. And then he cites each of the 4 times when the fuel filter, and only the fuel filter, is identified as the invention. And then on appeal, Honeywell argued that it was an error to limit it to the fuel system component. And Judge Lurie said the public is entitled to take the patentee at his word, and the word was that the invention is a fuel filter. So, and we got a few more slides on this topic here, some cautionary slides. But before we get to that, the invention, what is your best advice? What do you tell people about this? Because it seems weird that you can't use that when you're writing a patent application.
It is weird, but you got to play the game by the rules. And the guys in the black robes have said that if you say the invention relates to a fuel filter, you have just limited the invention. Now, does that map to reality at all? Absolutely not. Probably lots of the young whippersnappers in the audience have been following this sort of rule for their entire careers. But I can tell you that back in the day when we used to have to walk to work every day uphill in the snow barefoot, that we said the invention all the time. Yeah. Without ever meaning that this was a limitation. It was just you were generally talking about the invention. And so to say that the patentee meant something by saying, or the patentee's lawyer meant something by saying the invention, it just has no comport with reality. But if that's going to be the rule, then what I tell people is never say it. I mean, you can say something else. You can say, my personal substitute for that is the disclosure.
Yeah, the disclosure, right.
The disclosure relates to.
Right. Yeah, and that's, I think, probably the best way to do it. Because, and the thing is, and what makes this tough is that there's cases that say that when you use the term the invention is not limiting, and there's cases that say when you use the term the invention it is limiting. Now, if you wanted to really put if you really, I think, want to understand this, the next part of what Judge Lurie writes is illustrative or very instructive. It's the written description does not indicate that the fuel filter is merely a preferred embodiment of the claimed invention. So, if you're not talking about these pieces as being a part of the invention or as, one particular embodiment of the invention or one particular preference, or, if you're not talking about it in the alternative, you're just talking about it in the concrete, that's where you consistently run into big problems in this area. Now, there's other words that you can use, so you probably don't need to worry about this too much. The thing that I always want to point out to people is don't outsmart yourself here, though, because when I talk to, particularly this will be a lesson, I think, mostly maybe for the younger folks, like you were saying, who have never worked a day in the space where they were even allowed to write the word invention in a patent application. And I don't think a lot of them, at least based on the interaction that I have with them, because, you know, I teach this patent bar review course, and I've done that for about 18 years now, I don't get the sense that they understand why the rule is the rule. And all they know is we're not allowed to say the invention or the present invention because that's some kind of magic term. And it's really, I don't view it as a magic term. And I think it's wrong to view it as a magic term, so I put this kind of description together. It's like, if you say the stool has 3 legs of roughly equal length, which are attached at the bottom side of a relatively flat, smooth, circular piece of wood, then the second description is identical, except for it says the present invention is a stool. Okay, so now I'm using the words of present invention. You can fall prey to the exact problem that the rule, don't use the word invention, is intended to prevent by not using the word invention. Because in the first configuration, how many legs does the stool have? It has 3. Would a device that has more than 3 legs be covered? No. Would a device that has less than 3 legs be covered? No. It doesn't change anything by me not saying the present invention, because the way I described it was limiting. So I always just want to caution people, don't outsmart yourself and think that there's some kind of silver bullet here by all your disclosure problems are going to go away and all your concerns about limiting, unnecessarily limiting, are going to go away simply by not using the term the present invention, because you can walk smack into an unnecessary limitation never using that at all. And I wonder sometimes, based on what I hear from the new folks to the industry, whether they really understand that, you know?
Yeah, you've got to think about all the various ways to approach this problem to achieve breadth, and I think that is the most important thing to think about in when you're drafting. And as a result, in my book, that the first chapter is drafting for breadth, and it doesn't, you know, this. Most of the rest of the book is addresses particular areas like definiteness or whatever, but drafting for breadth takes in a lot of different techniques that and you can't just focus on don't use patent profanity. You've also got to think about using alternatives and variations, using generic language. You know, you look at that claim and, you know, and ask yourself, for example, is there some more generic term than stool that I can say, you know, so that I can describe this in very generic terms so that my 3-legged stool isn't the only thing that's covered by the claim.
Mm-hmm. Right. And let's get to that. I mean, I got a couple slides here. There's another case that much of what I just said about, you know, the invention is sometimes limiting, sometimes not limiting, comes from Absolute Software, where Judge O'Malley really explained it, you know, pretty well as she could, and gives examples of both situations when it is not limiting. So we have 2 slides here about that. But then I want to get to what you were just talking about, alternatives and variations, because that's going to start to open up the question about scope as well. And you have an interesting way, I think, Joe, to think about alternatives and variations. We always say you want to fill your application with as many alternatives and variations as you possibly can, because it's going to broaden the disclosure. But you actually define what an alternative is versus what is a variation. So what is the difference?
Yeah, basically here what I'm and first of all, let's be clear that this is fairly arbitrary, because you've got to make sure that that you're not trapped into the single body embodiment invention, because you're going to find plenty of cases. My favorite is the one of a refrigerated railroad car, where there was only one embodiment, one quick distinction, and what the court wound up saying was, in this case, the embodiment is the invention, and you don't want that to happen. So it would be nice if you could get the client to provide you with a number of different embodiments. The plain fact is most of the time that's not going to happen because they're not going to have the inventor doing that. So, but you as a patent drafter can come up with alternatives and variations. So alternatives and variations, both of these can be added by the drafter. You don't have to have the inventor have the inventor come in. So basically, here where you can come in with different ways of saying things. For example, you can think of an alternative. How many legs does your stool really have to have? Do you want it limited to 3? And the drafter can say probably 2 is not going to be a good idea. 4, sure. More than 4, if you want to, certainly. And you can state that as a patent drafter, and that broadens the scope of your invention, so you're not going to be limited to a three-legged device.
Yeah. Now, and then with variations, you look at them slightly differently as alternatives. This is where you're talking about how what you've already disclosed could be slightly different, not something.
Sure, exactly. And here, how many changes can you make in this device? So you've already talked about, in terms of alternatives, you can have 4 legs, 5 legs, 6 legs. With variations, you've said that they're wood. What else can you make them out of? What else can you make them with? What other techniques can you use for making them? So you, as the drafter, can build a variety of alternatives and variations to broaden out the scope of your invention. And if you don't think that's important, look up the plastic board case. I think it's Nyquist against Trex or something like that, and think about the problems that were raised there.
Yeah. And, oops, I'm going ahead because I wanted to ask you specifically here about this sugars case. This is another one of those cases that at the end of the day, it turned out that the drafter was vindicated by putting polysaccharides and saccharides together in the same group, but it cost time and money to explain that. When if you had given a little bit of thought about that, maybe grouping all those things together could create a problem, you could have drafted it such, even with another sentence or 2 max, would have eliminated all of those concerns. When these are very, very expensive sentences. And most of the time when you're reading these cases, and when you see a case where it's clear that the patentee is going to wind up being very surprised here, think about how much effort it would have taken to clear up the problem. And almost invariably, it is not much. Mm-hmm. Yeah. Yeah. And then, now, we're talking about choosing words here in Patent Optimizer. They can help you do that as well. They have obviously a thesaurus, but they can identify relative terminology, and it makes it really easy for you to find those things as well. Now, we got a question here as we're talking about language and we're talking about alternatives. It's probably more about variations and alternatives and specifically about the language that you would use to describe them. But, Joe, it says, is it recommended to classify in the disclosures the different, quote, best modes as alternatives?
you.